Wonderful. Well, thank you so much, Chairperson Silberman, for inviting me to testify. Last year, the District of Columbia took a tremendous step forward to protect workers from abusive non-compete agreements that limit their ability to work, seek higher wages, and advance in their fields. I've listened closely to the past testimony, and I want to point out that educational institutions, broadcasters, and professional sports organizations have continued to prosper in states where non-competes are totally banned, including California. But prior to the passage of the law in question, non-compete agreements here in the district were often imposed not on broadcasters, not on tenured professors, but on young or low-wage workers who do not have the legal resources to fight them. More so, they were often used to trap workers in jobs in which they faced abusive conditions, including sexual harassment and workplace misconduct. I know not because thankfully I suffered those particular conditions, but because I was one of the low-wage young workers trapped in a non-compete agreement. In September 2017, I was offered a job here in DC at a fundraising firm. As part of the terms of my job offer, I was required to sign a restrictive non-compete agreement that broadly forbade me from working for any business that, quote, engages in the same or competes with my employer for a year after the termination of my employment. There was no geographic radius set on the non-compete, and the specific type of employer it restricted was not defined outside of the text that I just quoted from. At the time of this offer, I was 22 years old and just a year removed from my college graduation. It did not occur to me that I could object to the non-compete, negotiate its terms, or ask for written clarification about its parameters. I wanted the job, so I signed the non-compete. A year later, when I tried to seek different employment, which in fact would not have fallen under the terms of my non-compete, I was told by my then employer that it would. I knew that it would not because I had done extensive research on non-competes, but I don't believe that that should be the burden for DC workers to have their rights protected. The Ban on Non-Compete Agreement Amendment Act was never intended to limit non-disclosure agreements. It was never intended to limit, very, very, very high income people from having agreements with their employers, but I want to strongly urge the council to refrain from amending the bill in any way that it will allow for non-compete agreements to affect lower income workers. I know that there are proposed changes that would allow employers to inflict non-compete agreements on their employees for 6 months with compensation. And I want to remind the council that the vast majority of non-compete agreements are imposed with a significant power differential between employees and employers. Opening the door to more of these agreements would hurt workers, not establish greater balance. I also want to point out that DC is an area with an extremely high cost of living, and the proposed $80,000 income threshold for non-compete agreements is roughly in line with 100% of AMI for a household of one, and is not a extremely high wage here in the district. Thank you so much for the time, and I want to express my support for the bill as it originally introduced last year.
Thank you, Ms. Kropper. And I have to say, I think you're the first witness ever to ask for their clock to start. So you could have gone a few more minutes and I would have looked the other way for giving your honesty. So thank you so much for your testimony. I'm sure there'll be questions for you.
So Ms. Kropper, are you still here?
Yes, ma'am, I'm still here.
Hi. So I am sorry to hear about the non-compete that you had experienced. That seems really overly broad and burdensome. It's my understanding that the Supreme Court had outlawed non-competes, or at least made them non-enforceable, that were not restricted to geolocations, and various state Supreme Courts have ruled similarly throughout the country, and so that should never have been okay, and I'm sorry that you experienced that. I think that some of the changes that we're talking about would not extend to that circumstance and would still make sure that those types of non-competes are banned. I wanted to ask you about the post-employment component, and you had talked about the need to be able to move on to a different employer, and that $80,000 a year is really not that much at 100% of AMI. What would you think about, from a fairness perspective, if the employer was responsible for compensating the employee the total amount of their annual income during the time the post-employment non-compete was in place for a period up to 6 months.
So sort of to respond to everything that you said, I think one of the biggest problems that you see, especially when non-competes are applied to workers that are new to the workforce, to low income workers, to low wage workers, is that there's enormous information asymmetry between what employers know and what employees know. So a lot of times you'll see employers imposing non-competes on their employees that are in fact unenforceable, which is why I think it's very important that the legislation as initially passed includes a provision that holds employers who do this responsible. But the problem is that when you begin to chip away at the law as it was initially introduced, you give employers opportunities to say to their employees, well, no, you don't understand the law properly. Here's this caveat, here's that caveat. And employees give up because they figure that they don't know as much as their employer. They figure they don't have the resources if a lawsuit comes up, and they give up and they leave their fields. I think that it is a very nice idea to say that there would be employers that would compensate employees for, 6 months out of the workforce. But I think in practice, what would be the case is employers would say, okay, you can have $3,000 severance, and we're going to enforce that non-compete. And DC law allows us to do that. I think it's very important to have a clear-cut law that very clearly protects workers. And I think that if you want to push that threshold up to $250,000, I don't have an objection to it. But I think given the high cost of living in the DC area, there is just no way that workers making $80,000 a year truly have enough power to push back against non-compete agreements and to negotiate with employers that have so much more power than they do.
Okay, thank you very much.
To ask you a few questions about how non-competes were used in your line of work. I know you testified and you've been very active on this issue, but not everyone is familiar with your story. So can you tell us a little bit, like how old you were, where you were, and what job were you hired for in which a non-compete was used? What did you know about the non-compete when you signed it? And then how did you learn how it might limit your opportunities?
I took the job when I was 22 years old. I was about a year and a half out of college. This was in 2017. I signed my non-compete as part of a broader package of paperwork that everyone signs when they start their job. I was fairly naive when I signed it. It was one of my first jobs out of college. I don't know that I paid a lot of attention to what I was signing at the time, nor do I think a lot of workers who sign non-competes do. And I became more interested in it as I was reviewing alternative employment options. I understood the non-compete to be fully enforceable, even though I learned later that it likely was not. And when I was thinking about jobs that I wanted after the fact, I looked at fields that would not violate my non-compete. So I moved from working in democratic digital politics, which from my understanding, I was banned from working in for a year, to a more traditional PR firm. Now, when I gave notice of my exit at the firm, I was told that my new job would be in violation of my non-compete. Now, I knew based on my research that it would not be in violation of my non-compete and that no court would ever, side with my employer. So I pushed back and I said, no, I am leaving for a firm that does not compete with this one, that works primarily in a different kind of advertising. This is not a violation. And so my employer, I don't think, was used to receiving that kind of pushback and said, oh, okay, you're right. You can, leave, whatever. But what I took that as was a very clear attempt to intimidate somebody who knew less about non-compete law than I did. And I don't think that we should place the burden on DC employees that they should have to have a nuanced understanding of non-compete law in order to seek new opportunities beyond their current field. So I retained a copy of my non-compete after the fact. I've actually sent it to the council for their review. The non-compete was very, very broad. I don't think it was enforceable, but that's not something that I would have known if I didn't do the research. And that's why I think it's just very important to make this law as clear cut as possible, because I think that if a worker who doesn't know much about non-competes sees a headline that says, non-competes are banned in DC, that's very clear cut. If they understand that, well, some non-competes are banned, but some are not, and there are specific provisions and specific incomes, I think it's very easy for an employer to say, this bill does not protect you, and for workers to believe that.
Thank you, Ms. Kropper. As I admitted to at the beginning of the hearing, I didn't realize that more entry-level employment in our city was subject to non-compete. I just thought of it as high-level employees. Is it your understanding, and you might not be able to answer this, that firm used non-competes for all employees?
That is my understanding, yeah. And my understanding is that entry-level salaries at that firm started around $35,000. I would also say that in my experience as somebody who's worked in advertising, it's a fairly common thing to apply to workers across all levels of the income spectrum. At the highest levels, workers were occasionally able to negotiate away the non-compete because they had that bargaining power, but lower level employees who often need those jobs the most either don't have the bargaining power or don't know that they would be able to not sign the non-compete. So my understanding is that at least in the field that I was in, it's very common for low wage workers.
Okay. And just for workers in general in that field. You're just saying if you're perhaps have more experience, you might bring a value to the firm that gives you some more bargaining power or negotiating ability. Okay. Thank you for your testimony.